uh, uh, dollar. Okay. It's like forcing that down a little bit. I would probably just.
All right, everyone, we're gonna, I think, get started in a couple seconds here. I think we have everyone that's able to make it is here either in person or online. Um, Welcome to the meeting of the Right to Repair Working Group. I'm Chris Tabb. I'm the Chief Deputy at the Maine Attorney General's Office, and next to me is Christina Moylan, who's the Chief of our Consumer Protection Division. And as we do at the beginning of every meeting, why don't we just go around the room and introduce ourselves? Megan, let me start with you and we'll work our way across.
Good afternoon. My name is Megan Sway. I'm with the ACLU of Maine.
Hi, Tommy Hickey, Director of the Maine Automotive Right to Repair Coalition.
Jack Quirk Auto Group.
Jeff Groves here on behalf of the aftermarket distributors and retailers.
Elizabeth Frazier, partner of Pierce Atwood, and here on behalf of the Auto Innovators.
Lynn Gardner, the Director of Legal Affairs for the Bureau of Motor Vehicles, and I'm here on behalf of the Secretary of State.
Eric Luftig, I'm with Dorman Products and I'm representing the aftermarket parts manufacturers.
Thanks a lot. And Brian, you want to go ahead and introduce yourself?
This is Brian Boggs here on behalf of Tesla Vehicle Manufacturer.
Great, thanks. And Tim?
Yeah, Tim Winkler with VIP Tires and Service.
Great, thanks a lot. So I think our plan for this meeting, from what we discussed at the last meeting, was to try to start having a discussion, sort of getting down to the nitty gritty and maybe putting pen to paper a little bit and starting to talk about the actual sort of form and content of the recommendations that we'd want to make to the legislature regarding the right to repair statute and the entity. And so just to remind folks, what the resolve says is that we are to provide the legislature with recommendations for legislation establishing an entity with rulemaking and enforcement authority to adopt standards governing access to motor vehicle telematics systems and otherwise implement and enforce Section 1810 of Title 29A. And so, as I've sort of mentioned before, I think there's a lot of different things that we need to be thinking about in terms of putting together those recommendations. I think we need to be thinking about what the structure of the entity is going to be. Is it going to be some sort of quasi-governmental entity? Is it going to be some sort of board? Is it going to be a state agency? I think we need to think about exactly what its duties are going to be, where in state government it's going to be housed, the extent to which it's going to need funding. And then if it does need funding, how is that funding going to be derived? There's a lot there. And one thought I had is it might make sense to sort of take things in small steps rather than trying to tackle everything at once. And just to throw this idea out there, there's still, at least in my mind, I'm not completely clear on all of the things that this entity is going to be doing. It does seem pretty clear to me that an important function of the entity is going to be to monitor compliance with Section 1810 and also have some sort of role in ensuring compliance, whether it's either through sort of achieving voluntary compliance or enforcement authority if necessary. So it does seem sort of that monitoring and enforcement is going to be a part of what the entity does. And then I also think that there's probably some role for this entity in terms of adopting standards that will be followed in terms of manufacturers sharing information. And I think those standards could be addressing things like privacy, security, and then just standardization. So what I'm wondering, just to throw the idea out there to the group, is whether it makes sense to just sort of first see if we can get to a place where we sort of have a better understanding of what we all think the independent entities' jobs are going to be. Because I think, you know, maybe I'm wrong, but I think that if we can sort of get to what we think this entity is going to be doing, then I think that's going to make it a lot easier for us to address the other issues, like what it should look like, how it should be funded, where it should be housed. So I just kind of want to throw that out there. And so let me stop there and see if any members of the group have thoughts or proposals about how to proceed.
Chris, do you think it'd be helpful to kind of remind folks back to our first meeting of kind of the purpose of the entity, the intent behind the entity? Just because now we're starting to put to pen to paper, we've learned from, you know, experts the last 3 or 4 sessions of, you know, folks in the field from independent repairs, et cetera. And I just want to remind folks of what the intent of the entity was, because there's been a lot of kind of misinformation throughout the campaign and throughout the, you know, back and forth of this. This entity was to be a group of experts that were going to look at how to implement the law and be a resource to, we saw this as something that the Attorney General would be implementing or at least enforcing. And this was to help the AG in its enforcement. So, you know, the meat and potatoes of the bill, as I call it, is for a standard owner authorized standard platform that the manufacturers would create, which would give information to car owners. And this entity would be to make sure that that was happening in a way that was best for the consumer and best for the aftermarket to keep that level playing field, which is what Right to Repair has been all about. So I floated this out last time, and one of the, you know, objectives of this entity, which I don't like the word entity, I think it spooks a lot of folks, but this working group was always supposed to be a group of experts from both the manufacturers and the aftermarket, but they were really supposed to be at the discretion of the Attorney General and in its enforcement of this. So that's always what it's supposed to be. I understand like rulemaking and stuff is in the resolution. I think that's something, you know, as we work towards it, this is really about the manufacturers and showing the Attorney General that this can be done and implemented safely. So I throw that at everyone's feet. It's just a reminder of the purpose of the entity. And as we move forward, putting kind of pen and paper to this.
And I forgot at the beginning, we're just going to try to either introduce ourselves or I'll just introduce you, just so because people online have a hard time seeing. But just for the record, that was Tommy Hickey who just spoke. So yeah, do people have responses to that or questions? Yeah, Elizabeth.
Yeah, I would just, I guess I would just look at the law itself, which I think clearly describes an independent entity with substantially more authority than the one that was just described. The law itself says that the independent entity shall manage cybersecurity access to motor vehicle generated data. The independent entity will adopt and identify and adopt relevant standards. So that's rulemaking authority, or at least akin to rulemaking authority, and then create the policies for compliance, et cetera. Those are all obviously quasi-legislative things that a rulemaking entity would normally do. But I guess I would just take issue with the characterization of the independent entity as some kind of advisory board when they clearly have legal authority as defined in the law that was written and passed.
Yeah, go ahead, Jeff.
So, I mean, we've had a lot of discussion about the language in section 2 and the paragraph that is the initial paragraph, and then as it ends, it says the independent entity shall, and it enumerates 3 different items: identify and adopt monitor and develop, create policies for compliance. It doesn't say it will have rulemaking authority. I think as I read this language, it seemed to me that what the intent was to create a body that would have expertise that could advise the Attorney General's office with respect to enforcement and with respect to compliance. And I think that having a body of experts that the AG would be able to ask questions of and get knowledge with respect to items like cybersecurity and privacy and those types of items would aid in that endeavor. Certainly, and you, Chris, mentioned at the last meeting you made an interesting comment which caught my attention about you questioned whether or not perhaps the entity was even needed or required, and maybe there was some language in maybe Section 6 or somewhere else that might need to be looked at as well. But that to some extent that resonates. Obviously, I mean, it is what it is with respect to what the car companies should be doing. Understanding how they do it and whether or not they are correct in saying we can do this, we can't do this, or why this is a good idea or a bad idea is something that I would imagine the AG would appreciate having some advice on, but perhaps not. This initiative was also passed in Massachusetts by 75%, not 85% of the vote, but by a majority of folks, and the entity was not a part of that. It's simply left to the Attorney General of Massachusetts to enforce the law. And so, I mean, that is one way I think that this could go as well.
Thanks, Jeff. Yeah, Elizabeth.
Yeah. I don't want to beat a dead horse, but I think there are two things here. One, if it wasn't intended as rulemaking authority or something akin to rulemaking authority, why wasn't a rulemaking authority included in the language itself, which was obviously written by the proponents? So as a lawyer, and I appreciate that not everyone reads it that way, but as a lawyer reading this with no actual language that says anything about being advisory or another entity having rulemaking or anything, I would read this, and I believe we would read this to mean that the independent entity is the entity that has authority here. So I appreciate the perception that others may have, but I think is in terms of the written law, it's fairly clear.
Yeah, Jeff.
Well, I think we can agree to disagree on that item. I don't read it the same way. I too have a law degree. But I think that's why we're here, is to figure it out. And what we have heard a lot of are questions about language and what does this really mean? And we need the proponent to explain it to us. And what we haven't heard are really any solutions from the Alliance and from Tesla, the car companies, the manufacturers, about a way to actually implement this. There seems to be more questions about why we are even doing this, which I think has already been decided by the voters.
Yeah, Christina.
I just want to get back to the question of what this entity should be doing. And, Elizabeth is talking about some of the language in the statute that talks about developing policies and identifying and adopting standards. I also hear about the intention that there should be experts advising the Attorney General. And I don't think those two things are mutually exclusive, because I think it would be really difficult for the Attorney General to figure out how to enforce compliance with this law without something in between the language of the law and a complaint brought to us for us to figure out from the experts, presumably, but guided by something objective that is developed to help us determine whether or not the spirit and letter of this law is being adhered to. And I don't know how we could do that with just a panel of experts advising us. I think there's a step missing that kind of, I think, bridges the disagreement between the two of you. I don't know. That's just my thought.
Yeah, Elizabeth.
Yeah, I don't necessarily know that we're having a disagreement about what are the words on the paper. It's just that, I mean, every Maine statute I've ever read that has some kind of intention of after statute policymaking includes rulemaking authority, and that's just clearly missing here. So you can read into it that there's rulemaking authority given to the independent entity, but as my familiarity with Maine law, it's simply not here. So I think that's I'm not so much disagreeing that there could be a panel of experts that would then have a conversation to some other entity or with rulemaking authority. But to my mind, the way this is written now, it is the independent entity as written in the initiated bill statute that has the authority to do the things that are clearly written that it has the authority to do.
Yeah, Jack.
Can you clarify something for me? Last meeting, we had one of the legislatures was here discussing a bill to do away with the entity. And if I remember correctly, that bill may come forward again and the legislature may be voting on it.
I mean, that's not something that I can speak to. There might be legislation that will be proposed again. We'll be in a new legislative session. So, there'll be a point in time when legislators will submit proposed bills, and that might be one that they submit. I don't know.
So let's suppose it was submitted and passed. Would that do away with this entity?
I mean, certainly, if this answers your question, I mean, certainly the legislature is free to do whatever they want with this piece of legislation. They could repeal it completely. They could get rid of the independent entity part of it. This is a law like any other law in the state, and so the legislature is free to do what it wants. This past session, there was a bill that, among other things, would have repealed the independent entity provision, and that did not prevail.
Right. Okay.
Yeah, Jeff.
There has been some discussion about what exists in Maine, or does something like this exist in Maine? I tried to do a little research. I'm not very good at it anymore, but I did notice there is a board called the Prescription Drug Affordability Board, which I thought might be close to what would be, in my opinion, appropriate here, which is made up of individuals who are from industry, or from pharma, or from the healthcare industry, that provide advice and guidance with respect to drug pricing, and so throw that out as might that be a potential exemplar that we might look at.
Yeah, that's a good idea. And Christine and I have been looking at some other models too, and I think there's a few other ones, but that one does sound like it might be a good one to look at. This might be a question for Tommy, but certainly if anyone else has thoughts. But most of the statute is pretty much sort of self-effectuating. I mean, there's all these requirements for manufacturers to comply with, for depending on the model year. So for 2002 to 2017, they have to do certain things. 2018 and later, certain things. Starting in January of next year, there's going to be a provision relating to access to the telematics systems. So I guess I'm just wondering, is there anything additional that would be needed in terms of this entity's authority to sort of carry out the statute? I don't know if I'm asking it very well, but I guess I'm just wondering, other than someone who's just going to make sure that manufacturers are complying with the law, is there something else that would be necessary for this whatever this entity is, to be doing to implement the law? Yeah, Tommy?
No, I mean, Jeff already mentioned it, but in Massachusetts, we didn't put the entity in charge of showing that it could be implemented. What happened is the Mass Attorney General said, you need to give us some experts when we get into this, because we need to know how to implement it. We need to know best practices. And so the thought process behind putting a working group here was just to assist the Attorney General. I mean, do I think there should be a group of experts from both sides that have discussions on best practices, evolving technologies? I do. That's the best interest of the consumer. So this working group, the independent entity, again, at the discretion and disposal of the Attorney General, but they should absolutely be looking at kind of ways to implement it as technology changes and compliance issues.
And is there anything you can speak to about what's going on in Massachusetts. I mean, as I understand it, even though the law is in litigation, I don't think it's been enjoined. So do you know, are manufacturers complying with it? Is the Attorney General enforcing it?
It's in a gray area. You had the National Highway Traffic Safety Administration come out against it and then revert back to saying that there are ways that it could be implemented. And with a judge not making a decision on kind of where that court case stands, I think the Mass Attorney General is, looking at her options on how to best implement this in a pragmatic way. Now, having said that, we're continuously having conversations with her because, again, the whole point of the entity is to show that it can be implemented, and they don't have that kind of working group in statute put in place to assist the AG. I mean, we think that if you got the manufacturers and the aftermarket and the independent repair community, as well as privacy groups, et cetera, to get in there and show the AG that this can be done, just as you saw a few weeks ago with the proper folks, then we'd be up and running in Massachusetts. And that's really the entire point of what this working group is supposed to do.
This is Brian Boggs. It's interesting to hear that the whole point of the independent entity is to show that it can be implemented. That makes an assumption that it won't be implemented. Chris mentioned earlier that the rest of the statute is pretty self-effectuating, that it mandates manufacturers make repair and maintenance information available, that they sell their scan tools to independent repairers, that they offer their scan tools at fair and reasonable prices, that the manufacturer must empower other tool manufacturers to make their own scan tools such that they don't have a monopoly on the scan tool market, that the manufacturers must make the same telematics information available to independent repairers that they make available to dealerships, and includes a monitoring and enforcement mechanism to ensure compliance to the statutory mandate through existing government oversight via the Attorney General. So if the if the main point of the independent entity is to show that it can be implemented, I guess I don't understand why that is needed. Like if the rest of the statute mandates that it is implemented and there's an enforcement mechanism, then the manufacturers can get moving and make the implementation. Like I fully believe that that we're now 3 to 5 years behind Europe as a result, unintentionally, of the bill in Massachusetts and of this bill in Maine, that the manufacturers were hesitant to offer solutions because these bills were going to be written in a way that mandates a very prescriptive, a specific way to implement the solution. And Europe is already off and running. Like, independent repairers have access to remote telematics data. It's owner authorized, and but in North America, we're here at a standstill, accidentally, as a result of these bills. So, like, my main fear is that the independent entity will adopt very specific standards that constrain innovation and result in a slower implementation. Like, for example, we heard from an expert either in the last session or the session before about the SOVD connectivity concept. And there are other models like SVI, or the extended vehicle concept. And I think it is incorrect to view this as a zero-sum game where it's either or implementation rather than all of the above. And my impression is that what the voters want exists throughout the rest of the bill. And if the main point of the independent entity is to show that it can be implemented, I guess I don't see that as a compelling argument to create quasi-governmental agency or a state agency with rulemaking ability.
So Brian,
Go ahead.
I believe, sorry, I believe that Tesla was not a part of the alliance of auto innovators in the last 5, 6, 7 years. But the manufacturers have often said that this bill is written, it's not possible to implement. The technology doesn't exist. Since about 2016, 17, the aftermarket has been trying to sit down with manufacturers to show that this, can be done and to hammer out telematics, and they just kind of throw their hands up. So the entire purpose of the working group was to what you just said, Europe's already ahead of us. Why can't this be implemented? Well, when they say they can't do it, the Attorney General is not someone who's going to have the expertise to do it. So the working group would be to have both sides hammer out exactly how this is going to be implemented for what the mayors voted for.
This is Brian again. I believe the challenge there is the specific implementation, like prescribed by the independent entity of a standardized implementation across all vehicle manufacturers just goes against every cybersecurity best practice and different mandates from FMVSS and NHTSA describe best practices. So that's the portion that I believe that they were pushing back against, as opposed to the idea that whatever telematics information is made available to independent repair or to a manufacturer dealership would be made available to an independent repairer, which is mandated elsewhere in this bill, and there without a dependency on the independent entity existing.
Elizabeth?
Thank you, Chris. Okay, so some of this goes back a little bit now because I've got notes from a couple things that have been said. So I believe it was either Chris or Tina, I don't remember who asked about compliance in Massachusetts. And Tommy's correct. It's kind of, up in the air in terms of what the enforcement's going to look like or will be. But I can share that both Subaru and Kia have preemptively shut down telematics in their vehicles in Massachusetts. So you can't use a telematics system in a car by Subaru or Kia. And that was obviously a decision on their part, a business decision for compliance and risk reasons. I don't know more about it than that, so don't ask me more about it than that. The other thing I wanted to mention is we've heard a lot of conversation in the last few weeks about, the NHTSA letters. And I wanted to just clarify that, the letter everyone says, oh, NHTSA wrote back and said, oh, yeah, you can do it. I thought it would be helpful to read from the language exactly what they did say. So obviously there was the original letter saying this can't be done, you can't do it. They were pretty, I would say, not dramatic, but alarmist about it, I think is fair to say, because they had really significant concerns. So this is their response to their previous letter. Based on our further conversations, NHTSA understands that according to the Mass Attorney General, one way that vehicle manufacturers can comply with the law is by providing independent repair facilities wireless access to a vehicle from within close physical proximity to the vehicle without providing long-range remote access. For instance, NHTSA understands that according to the AG, vehicle manufacturers could comply with the law by using short-range wireless protocols such as Bluetooth to allow the vehicle owner to authorize data, et cetera, et cetera. And it goes on to talk about a few other things, but that specifically to the point of whether or not the sort of whole concept is workable. They essentially said it is workable so long as you're in close proximity, because their concern is that if automakers if we're not holding the key to who gets access, who gets to have access to the data, then if that data is not clearly defined within a short range period of time, I mean, if you're allowed to access it while the vehicle is moving, which is that is how essentially the law is written right now. There are obviously very big concerns for NHTSA about that come with car safety. If a vehicle's moving, you don't want someone hacking it or having access to it or be able to upload in real time inputs and downloads. So NHTSA's response letter, to be clear, says that it can work so long as the vehicle is in close physical proximity. And I haven't heard anything about that with respect to a potential solution.
Yeah, Jeff?
NHTSA also says in its letter that NHTSA will continue to evaluate safety programs and protocols as technology in this area evolves, which may also enable additional safe compliance pathways under the Massachusetts Data Access Law. So I don't think that their letter meant to preclude other avenues, be that as it may. Part of the entity, part of the expertise that's talked about in the main law is to set the parameters and the guidelines for what is appropriate and what isn't. To your point, Elizabeth, I think, you shouldn't be able to have access to a car while it's moving. I think that's one of the parameters that probably everybody could agree upon. And so, I don't think what this law does is allow free and unfettered access to motor vehicles by anybody at any time for anything, but a very controlled access. And that's what, the experts were meant to do. And a cross-section of experts, including folks from the manufacturers, to have a dialogue about here's what we do and here's what access we allow and why we allow it, and here's the access that we don't allow, and here's why we don't allow it. And to perhaps try to mirror that with respect to independent repair shops. We've not yet been able to have that dialogue with manufacturers to really understand what that might look like. But really that's kind of what this policy section is designed to do, is to fill in those blanks so it makes sense to all of the stakeholders.
Tommy?
Yeah, I'd also add too that, what we hear is that it's the car manufacturers only. They're the only ones that can dictate who gets this information. They're the only ones that can keep it safe. I mean, every cybersecurity expert has looked at that and said that that's false. But I'd also mention that this is owner authorized. That's the entire purpose of this. This is about the owner dictating who gets the information to fix their cars. I mean, we're talking about diagnostic and repair information. So again, we all go back to how the manufacturers read the NHTSA letter, how we do. That would be the entire purpose, again, of the working group, to create that policy. But Bluetooth is not a level playing field. So if manufacturers are using cellular activity to connect to the car and bring it up into their cloud, and we get Bluetooth, that puts the consumer, puts the independent repair. It's kind of worthless to give Bluetooth technology to someone when they have cellular activity. That'd be like saying, I can only talk to you when I'm in this room, and as soon as I leave this room, I can't call you. I can't get in touch with you. So I think it's important to remember that this is an owner authorized platform. This is up to the consumer. It's the consumer's information, and they should be able to share who gets their repair information.
Yeah, Elizabeth.
I don't know the answer to this question, but one of the things that I would imagine would concern, regulatory agencies with the notion that we're gonna somehow take all the vehicle's data and because this, I have to be honest, this still has not been clear to me exactly how this would work, but hold it somewhere that is not held by the manufacturer, and that owner of the vehicle would then be able to say, yeah, okay, I own the data, and so this person can access it. So it's still not clear to me, and I think it would be of significant concern to the manufacturers that someone still has to be liable for having granted that authorization. Is it now the consumer? Is the consumer liable? And if so, how does that help the I'm genuinely confused about if manufacturers are no longer the sole holder of at least it can be an owner says, give me access to this independent repair. And we could say yes, but we have to be the saying of the yes, because it's not been made clear to me who else would be the saying of the yes, who would hold that guard, that sort of gatekeeper responsibility. And so that's one of the questions I have about
the language of the bill makes it seem like that's the independent entity. It says it will administer access. I don't have any other way to interpret the word administer access.
So, and this is Chris. I mean, I do read it differently. I don't read administer access as necessarily holding the data, but I think it could also refer to setting sort of the administering the process by which owners and independent repair facilities will access the information that's held by either the vehicle or by the manufacturer. And that aside, though, I've just sort of been thinking that we were, and maybe I misinterpreted sort of some of our earlier discussions, but and I don't disagree that there is some ambiguity. And Brian, I think your reading is a plausible one, and maybe it's the right one. But I thought we were at a place where at least we were sort of in agreement that the intent of the law was that there wouldn't be an independent entity holding all of this data. All of the data would remain where it is, whether it's on the vehicle itself or maybe it's uploaded to the cloud of the manufacturer. And then the manufacturer would be the one saying yes. And they would be saying, yes, you can access it from that vehicle, or you can go up in the cloud and get the data about that vehicle.
So
yeah,
it was that portion that that I was referring to, not the holding of the data, but after the owner has authorized the independent repair, who is it that grants that access? Who says yes? Is it the vehicle manufacturer or the independent entity? And so when I read the word administer access, to me, it implies that the independent entity is the one that says yes, that this independent repair, who's now owner authorized, shall be able to access data from the vehicle. And therefore, the liability of correctly saying yes or no, it shifts from the vehicle manufacturer to the independent entity. And both NHTSA and I, as a vehicle manufacturer, think that the responsibility needs to remain with the manufacturer such that they can be held accountable.
So I don't know, Tommy, I'm sorry.
That's okay.
Elizabeth,
I just want to echo what Brian said.
Okay.
That's exactly right. It is ultimately about who's going to hold the key to say, yes, that independent repair person can have access, because it has not been made clear to me who or where that would reside.
So I'm wondering, just Tommy, can you maybe speak to what the intent is? Is the intent that the independent entity will be the one saying yes or no to someone who wants to get vehicle information?
No, I think, again, a lot of this working group was for this group to get together and develop policies and develop standards. And then again, if we have to add this section, which I've talked about, at the discretion of the Attorney General, then that would be it. If the Attorney General thinks it's safer for manufacturers to sign off, I don't think that's something we'd be comfortable with. But I think, again, this is an owner authorized. So this is, if manufacturers can collect any information and sell this information to insurance companies, are there safeguards on insurance companies when they dictate where that information goes? I mean, we always talk about how unsafe it is for owners to have their own information. This is diagnostic and repair information. So as to who grants access, it should be the owner who grants access. It's no different than when I have my location, and we both have iPhones, Chris, and actually I don't know if you do have an iPhone, but neither here nor there. If I grant that information for you to have that, and then I revoke that information, that's up to me. And that's the entire purpose of this bill.
Example, Apple is the one, after you say yes, Apple is the one facilitating the transfer of that data to whoever you authorized. It isn't a government-run independent entity that receives the electronic, like, cryptographic keys from you and transfers them to the third party that you are authorizing.
No, but we're a manufacturer to restrict any access from the car owner who's granting that access. This working group would assist the AG in making sure that the manufacturer was not doing it in an ill will towards the consumer, correct?
Yeah, that's in the enforcement section in Section 8 that the AG would.
Right. So that's I think the entire point of the working group that you've just pointed out here.
Eric, did you have a comment?
Yeah, I just wanted to be reminded, Brian, in the world of Tesla, I think you shared before that it is the consumer that's granting the access to the independent repair shop. So, right? Isn't that how it works today?
That's right. That through a mobile app, they can grant access to an independent repair and the facilitation of how that works electronically is administered by Tesla, the vehicle manufacturer. And that was actually the same framework that I forget the name of the expert, but he described the SOVD concept and how OAuth 2 was the authentication protocol used to within that framework. So I fully agree that the owner is the one that should be authorizing an independent repair. But the administration of the electronic transfer of those cryptographic keys between the owner and the vehicle to the independent repairer needs to be administered by the vehicle manufacturer. I think we discussed maybe in one of the first sessions this analogy of a safe. Let's imagine that each vehicle manufacturer has a safe, and within the safe are the cryptographic keys to each of the vehicles that they manufacture. And when owner authorizes an independent repair to have access to their vehicle remotely, the vehicle manufacturer opens the safe and hands out the cryptographic key to the independent repairer. Where I take issue and what the cybersecurity best practices take issue with what's written in the independent entity section is that it implies we would take all these safes and consolidate into one single safe that is administered by the independent entity, such that the independent entity is the one that hands out the key. And that's some of the best practices that goes against is diversification, that now it's a singular attack surface. And it's actually a much larger honeypot that it's much more attractive to attack this safe because it has the keys to every vehicle in the state of Maine. So if I wanted to, if I crack that safe, I can honk the horn or deny use of every vehicle in the state of Maine, as opposed to just the vehicles manufactured by Tesla or just the vehicles manufactured by Ford. And another core principle of cybersecurity is that no matter how hard you try, all safes are crackable. That if you begin to envision, oh, I'm just going to design the best safe that cannot be cracked, that's like an immediate fallacy. And so the best practice is to assume that all safes are crackable, and that when they are cracked, the administrator of the safe should be the one held accountable. And today, that is the vehicle manufacturer. So I worry about shifting that accountability to the independent entity in its administration of access to the cryptographic keys inside the safe.
Jeff?
I think Brian's reading of the language in the statute, while it certainly could be a fair interpretation of the language, is not what is being suggested. And I don't think this contemplates creating a state-run agency or independent entity that has a database that is responsible for handing out that information. That would be akin, in my opinion, to sending a spaceship to the moon. I do agree that all safes could be cracked. I think Tesla's could be cracked, and all the manufacturers could be cracked as well. But the issue in my way of thinking is, do you get the information from the manufacturer? Can you get the information directly from the vehicle? And I think that the consumer, the owner of the vehicle, the one that's paid the money for it, the one who has to get it fixed, who has to drive their kid to school, should be the one to authorize that. And I think it could happen both ways. You could get the information directly from the vehicle, or you could get the information. You'd have to go to I guess in this case, if it was a Tesla, to Tesla's cloud to get the information. But there's certainly a way to do that without creating a separate entity that's going to house a bunch of data and be the keeper of keys. I don't think that's what anyone's suggesting here.
Yeah, and I think, one of the concerns we heard during the public hearing was that maybe there should be some sort of vetting process for independent repairers who are going to be getting access to the data. which, that did sort of get some traction as far as I was concerned, because it does seem like currently there's a pretty small universe of people who have access to the data. This is going to broaden that universe, and so maybe there should be some sort of vetting process or credentialing process. And so I guess what I'm wondering is if maybe the administer access refers to things like that. Like, for example, administer access could mean that there are going to be some guardrails so that manufacturers only have to turn over the information to an independent repair facility who has somehow been vetted or established that they're verified and that they're properly credentialed or something like that. That said, I mean, I agree with Jeff that I don't think that I could ever recommend to the legislature that this independent entity would be allowed to be the gatekeeper for all of the data. And to the extent that we think that the statute needs to be tweaked to make that clear, then, I would support that recommendation. But I've always, in my mind, thought that this would be a system where there might be some criteria or qualifications or guardrails that this independent entity might be setting. But at the end of the day, the only person who gets to turn on or off the access would be the manufacturer. Yeah, Elizabeth?
So I agree with what you just said, but that's not what we're hearing from the folks who want this, right? They don't want the manufacturer to be able to turn off that access. I'm not actually sure who would be doing it at this point. It sounds like the consumer. Vehicle data doesn't just live on a car. I mean, I guess we could cut it off from the cloud, in which case I'm curious, who has the liability here? Is it the consumer? Is the consumer then personally liable for whomever they authorize to use their data? I don't think NHTSA would be wild about that. And if it's not them, who is it? Because I don't think manufacturers are going to be comfortable being the actual holder of the data, right? It goes up to our cloud. You're essentially saying, yeah, hold on to it, give access to anybody we want, and that'll be fine. There won't be any negative consequences there. And I think that's where we have severe concerns about risk and compliance.
So on the Tesla example, how does that work today? Your concerns?
On the Tesla, what example?
Well, you just said your concerns were around who's liable.
Right. So currently Tesla is authorizing the independent entity. So Tesla has the liability. So I'm trying to figure out, if we take away Tesla's ability to be the final authorizer, who is it?
But I'm saying that I don't think we're taking that away.
Okay, I want to be clear that that's not what Mr. Hickey just said he wanted a few minutes ago.
Maybe I misheard or misinterpreted, but I sort of think that we're all on the same page here, maybe. I think we're all in agreement that this independent entity is not going to be the one that's going to physically grant the access, that the independent entity might set some standards or credentialing criteria or something like that, but it's going to be the manufacturer who will actually provide the information.
At the request of the consumer. So the consumer says, I want to share my information, and Tesla facilitates it. But
is that, I mean, let me just go on the road.
It might even be more helpful to just give you an example of where I see the working group getting involved. So I'm driving a vehicle. I want to grant Tim Winkler access to remotely diagnose my vehicle. He tries to get access to the information. He can't. I'm driving whatever kind of car. I don't want to point at a manufacturer. I complain to the AG's office that Tim Winkler can't fix my car, granted under the right to repair statute. The AG's office has to go figure out why it is that Tim Winkler can't fix my car. This working group, with experts from both sides, would be able to assist the AG in enforcing or figuring out, investigating as to why I, as a car owner, granted access to Tim Winkler to my car and he couldn't fix it. That would be the reason behind the working group. Because right now, if you have manufacturers saying, I'll give it to Tim Winkler when I want, I'll price it how I want, it's me as the car owner who should be granting that access. So that would be why one of the roles we see the working group going in. That's why when you're looking at, administering access, I mean, that would be considered access, right? You'd be looking at why it is that I can't share my information with Tim Winkler right now, and that would be helping the Attorney General investigate into that.
So let me just back up for 1 second, because I just think this is like a fundamental thing that we've been talking about a couple of different meetings, and I just want to see if we do have agreement. And let me just sort of say where I am in this, and then just see if people disagree. But my thought, and if we have to tweak the statute to make it more clear, then that would be one of our recommendations. But as I interpret the statute, or as I think the statute should be interpreted, the independent entity is not going to be the holder of the data. The data is going to remain wherever it currently is, whether it's on the vehicle itself or in the cloud of the manufacturer. Nor is the independent entity going to be deciding who gets to look at that data. It's going to be an owner requests that a particular repair shop have access to the data, and then the manufacturer is the one who provides the access. And then when the owner says, I don't want that person to have access to my data anymore, then the manufacturer is the one who tunes off access to that. And so let me just kind of look around and see if is that how other people are thinking that this should work, even if maybe the statute doesn't say that exactly. Is that kind of what people are thinking it should work? Yeah, Elizabeth?
I can't really say one way or the other because, I mean, yes, to some extent, I hear what you're saying. Yes, there would probably need to be other changes to the law to provide that clarity. And I don't just mean in the independent entity section, right? There's this whole thing about a standardized platform. And that would imply that it's no longer the automaker who's using their own authorization system. It's a standardized platform. So that's where I get back to, which sort of sorry, I got distracted. I guess I would just get back to if the platform the platform is standardized, the idea being that therefore it's no longer the manufacturer's final approval on the access, right? So that conflicts with what you were just discussing. So I think the section on required equipment have to be looked at too, to get to what you were just describing.
Hey, Chris, this is Tim.
Yeah, Tim, go ahead.
Yeah, I guess I would just like to, point out or talk from the perspective of, in the shops today and in the past, forget about telematics and remote access for a moment, right? The way that Jack's technicians and our technicians access data from the vehicle is through the OBD2 port. So there's these tool companies out there that build scan tools, and they have pretty much standardized how you access data on a vehicle. And maybe I've been wrong, but my layman's way of talking about this standard platform has been like the OBD2 port in the air or the OBD2 port online, right? So if a vehicle, and some of us, even Brian, probably as forward thinking and is interrupted as Tesla has interrupted the automakers world in the last 10 years or whatever, we may have Chinese EVs coming in 5 years from now that who knows what kind of technology they're going to use and how are they going to comply with something that we want to make sure that American consumers and Maine consumers specifically are protected and are able to access the data that their cars produce so that they can choose their repair method. I guess for me, that was the idea of this remote access system, was a replication of the OBD2, the way it works when it's all on the vehicle, when there is no remote access. So, that means that hopefully 5 or 10 years from now or whenever, we've got scan tool makers who can also market and sell products to technicians that allow them to input a code that the consumer gets from their car manufacturer so that their scan tool can now access the data that the vehicle produces, but doesn't flow through the OBD2. That's kind of like, from a simple man's perspective, how I always thought about this. And the reason that I think we had to write some of this language in here is because it's kind of we're blazing a trail. Like, this hasn't been done before. And like Tommy said, the Massachusetts AG was like, we don't even know how to do this. And we said, well, we should probably put a group of experts together to help the AG figure out how to make sure manufacturers are complying with giving the consumer the ability to direct this data that can't be gained from on-vehicle systems.
So this is Chris. I I read that provision a little bit differently, although I might be reading it wrong. So I don't know, but I think Tim, you were looking at the provision that talks about in section 2, which talks about the independent entity, and it talks about establish and administer access to vehicle generated data that is available through the onboard diagnostic system or that is transmitted by the standardized access platform authorized under this section. Is that, and then,
I always use the term standard access platform. To me, the idea of a standardizing the same way we standardize the on-vehicle data, we have to standardize how we access it when it's not on vehicle.
But then there's another provision. So in section 6, which talks about the telematics system, it talks about equipping vehicles with an interoperable, standardized, and owner-authorized access platform across all of the manufacturer's makes and models. So what I was wondering is if when it talks about a standardized access platform in section 2, it's not referring to a standardized access platform that the independent entity would establish, but the standardized access platform that each individual manufacturer would establish for all of its vehicles. But
I think that would be fine. Whether it's standardized across all vehicles and the manufacturers decide there is going to be standardization, or whether each of them has their own standard that they're going to use to allow that flow of data to happen. I think either one of those, from our purposes, fits the need, right? So we just want to be able to access the data. And, once again, in my mind, it's like, well, how does my technician get to the data that they need to get to when it's not available through the OBD2 port?
Right.
And if the manufacturers are going to work with the aftermarket and work with the tool makers to provide a system by which independent technicians can access that data, then that's ultimately what we're looking for. But we've run into too many roadblocks trying to sort of all get on the same page. So I think that's maybe why the law itself tried to prescribe a method by which we say, here's how it can be done. So everybody can get on the same page that let's go get it done.
Yeah, I think this is Brian Boggs. My challenge or my problem with that is here's how it can be done versus here's how it must be done. I worry that we're at this inflection point in so much new technology coming on board that the independent entity may adopt standards that restrict innovation and limit the capabilities of technicians or consumers because it only allows for one way of solving a solution rather than simply mandating that a solution must be available, but not dictating the specific implementation of that solution. And I would also like to mention that in my interpretation, the section 1 describes that the access to the vehicle may not require authorization. But if it is going to require authorization, it needs to be the authorization is standardized, and both the section 2 and the later sections use the phrase authorization platform or access platform. So what is the role of the platform? The role of the platform is to grant access, and the standardization is about access. It's not actually about the information flowing through the port or flowing through the telematics. So
yeah, I guess, Brian, I read the standardization idea as, like I said, the OBD2 idea, right? So if 30 manufacturers each come up with some different architecture for the data, and now a technician has to buy 30 scan tools, we've made things a lot harder.
Yep. As an engineer, what I see is that vehicle technology is rapidly evolving. Some cars have one gas engine, some have a gas engine and one electric motor, some have two motors, some have four motors, some have wheel-mounted motors, some have power assist through the steering system via vacuum, some are electric power assist. There's all sorts of different permutations. And if the standard dictates that very specific values, like specific data values, must be available, well, those data values might not be relevant to a vehicle that has one motor or four motors, or it might not accommodate a concept of a vehicle that has eight motors. So that's where I would like the focus to be on ensuring that technicians have access to the data, but not mandating the specific structure of the data or the specific data values that must be available.
So Brian, to your point though, that's
Hold on. I think Eric was gonna.
Yeah, no, just I'm reflecting on what Tommy had said earlier. We're kind of swirling at the top down of what this entity is and what it would do. I kind of like maybe going the approach of here's a real world example. What do we need to do to actually solve that either through the AG and or through this advisory entity in that real world example? I'm just wondering if that might be a way to attack this versus swirling at the top, maybe taking the bottom up. Here's the problem. This is a real world situation. Vehicle X, owner Y, independent Z can't get this repaired. What do we actually want to do? What can the AG do, and what would this group do? And then can you build it that way? Here are the things that need to get done in order for that person to get their data and get a proper repair. It was a very, very simple example he just gave. So, is that a way to attack this thing? Actually build it from that. What do we need to do? Brian, you probably know best. What do we need to do to solve that?
Well, I mean, I just want to.
Yeah, go ahead, Tommy.
Yeah, like Brian was just talking about this. There's going to be all kinds of technologies that are going in vehicles. It's going to get bigger and bigger and more. And that's, if you look at the language, it says develop policies for the evolving use and availability of data generated by the vehicle. So that's the entire purpose of putting a group like this together. As technology advances, and a lot of this is great technology, it has to be done correctly in the best interest of the consumer. So what you've spoke about is how cars are created and how they're going to continue to advance is one of the reasons you want to have an ongoing basis of a working group to assist in the implementation of this. And I go back to the standardization issue. This was the exact issue in 2012. And I know you talked about the OBD port being standardized in 1990. We can do it for wireless. We have the abilities. We have the standards that already exist. And so while I agree with you, Brian, I don't think this is going to be a one size fits all. We see this as parameters in which this law has to be implemented. So as long as you can get information to a car owner and they can share it with an independent repair shop and they can make a full repair of the car, I think you're all set as far as a car manufacturer goes. This working group is going to be showing the way, because a lot of times manufacturers are going to throw their hands up and say it's not possible, it doesn't exist, and they're going to be assisting the AG in making sure that this law is implemented.
And Tommy, you said the working group a couple of times, so I think you mean the independent
Entity,
right? Okay, yeah,
yeah.
just want to make sure. Did you have something? Christina.
Hi, Christina Moylan from the AG's office. I think a lot of the conversation that we're having is a conversation that doesn't is kind of putting the cart before the horse a little bit. I think we need to come back to what is it that we need the independent entity to do. And I think to Chris's earlier point about amending the statute without changing the basic premise of the statute, there's a lot of room, I think, to change the language, improve the language. And if we're all on the same page, or at least, try to get most of us on the same page about what the scope of the authority should be of the independent entity, I'd kind of like to get back to that question that Chris posed. I didn't hear any disagreement, but I'd kind of like to get back to that question that Chris posed about, does anybody disagree that the independent entity, how the independent entity would be requiring access, but not necessarily prescribing how access happens, maybe vetting some of the independent repairers, how do they do all those things? Should there be rulemaking authority? But also just the basic premise of, does the independent entity not house data? And I kind of thought that everybody was on the same page with that, but I didn't hear anybody. I just didn't hear people respond to that. And I kind of like to get back to that underlying question. Elizabeth?
Sure. Yes, I can try to respond to that. And you might need to get you to re-ask your questions again so I get them all. But I mean, I think first of all, the question of what gets left to the independent entity and what its actual legal form is very important. Because as it's currently set up, I don't know if I can even speak for my client here, but just as a lobbyist and someone who does work in it is in a very uncomfortable position somewhere between being a government regulatory agency and being something independent, completely independent with no oversight. Who's the oversight agency, right? So if they're suddenly going to come up with standards and those standards can't be met by the vehicle manufacturers, or they're not good standards, or maybe they're whatever happens, maybe they run out of funding, or name any one of circumstances in which an oversight entity would normally step in, maybe that's your office and the rulemaking goes to your office. I'm not sure. As it's currently structured, it's just not, I still don't see the reason for it as it's currently structured. We do rulemaking all the time with plenty of, stakeholder meetings and comment, and everything I've heard described could be done through that process. So I certainly would agree that that would be the purpose, and that they could then take a look at parameters and stuff like that. I would agree there shouldn't be a platform that the state, the independent entity is holding data on. I would just reiterate that I don't think that is clear in the law now, so we would want to clarify that. But yes, I think if that is everyone's intent, that is appropriate.
Well, does anybody disagree with that? This is Christina Moylan again from the AG's office. Sorry, can we at least establish that we've got that common understanding?
We articulate the common understanding again so that I'm clear what that really is.
Well, that's a fair question, actually, because I guess maybe it's for Tina to articulate her understanding and make sure that I had it right. And then, because I'm just worried about, are you thinking about converting the independent entity to a type of working group? Is that what you're describing?
No. I'm just trying to establish that we've got a common understanding that the entity would not actually be in control of any data. They would not have a standardized platform that they can, yay or nay, provide actual access to data that they're in charge of.
Yes.
I agree.
Yes.
I partially agree. I agree if you say we're talking about vehicle data. I actually think that there's additional data that is worth discussing here, which is the information about the independent repairs and the information about the vehicle owner. In order for a manufacturer, in order for this process to work, there has to be information about which vehicle is owned by which owner. There has to be information about which independent repair is associated with which account, like an electronic account. And then there's the vehicle data itself. So for a question, if we're just talking about the vehicle data, I agree that the independent entity doesn't necessarily need to house that data, but I'm less clear on the other two because we haven't discussed it.
And this is Chris. I'm sorry, Brian, can you describe what this other universe of data would be?
Yes, let me see if I can find something that will help explain this. Okay, somebody mentioned we should walk through a real life example. So let's assume that there's a vehicle owner. Let's say it's me. I own a car. I live in Maine and I go to Augusta Auto Repair and I want to authorize a technician that works at Augusta Auto Repair to remotely interact with my vehicle. Then either I initiate a request for that technician to have access, or it's the inverse. The technician initiates a request that goes to me that they would like access. And so that electronic request, because we're talking, this is all remote, so everything's electronic. Somehow that request needs to go from the technician to me as the vehicle owner, or from me, the vehicle owner, to the technician. So that on its own assumes information exists somewhere of a vehicle owner's account and a technician account associated with Augusta Auto Repair, which is a business. And additionally, there has to be some relationship between, let's say I grant that technician access to my vehicle. Well, I have a specific vehicle that says VIN number 5 of a Tesla. It's a Tesla. And so now that technician needs to remotely connect to VIN number 5. So there must be some account that exists somewhere, some database that exists somewhere that links me as a vehicle owner in my electronic account to this electronic vehicle. It's a digital asset, an electronic asset. And so to facilitate this, where I have some digital certificates or tokens that I'm going to hand over to this independent repair, specifically the technician, and then they are going to use those digital certificates to remotely connect to my vehicle. None of what I described actually talked anything about the data that exists from the vehicle itself. It's information about me, like who am I, what vehicles am I authorized to grant access to, and it's information about the technician, and such that they can receive the access. And in the status quo world, this information is housed and administered by each vehicle manufacturer. That GM runs their OnStar network. They know which vehicle owners can access their own cars through their OnStar network, and so on. So that's what I was referring to.
So this is Chris. So, I mean, it sort of sounds like at least one issue is there needs to be verification that the customer actually owns the car that they want the repair shop to be able to access, right? Because we don't want to have a situation where, you know, I want to mess around with my neighbor or something, and so I somehow convince a repair shop to get access to that car. So is what you're saying, Brian, that at least part of this process needs to include like a validation that the consumer really does have the right to authorize access to that particular vehicle's data?
Validation sounds great, but I was actually just describing a much more simple mappings that, like, who owns this car? If you walked into a parking lot and you looked at a car, which individual has the authority to grant remote access to that random car that you're looking at? There has to exist a database somewhere that maintains that relationship. Today, those databases are housed and administered by the vehicle manufacturers or the connectivity service providers that they work with. And yeah.
I mean, I think at least if it's a Maine registered vehicle, I'm also assuming that the Secretary of State's office is going to have data on who owns a particular vehicle.
Well, they have data on who owns a vehicle, but that is not necessarily one for one the same as who has authority to grant remote access to that data, to that vehicle. Like you and your spouse, or your if you have a child, like your teenager brings a vehicle in to get repaired and get the brake serviced, you might bequeath upon your child that, yeah, sure, they can authorize an independent repair to access the vehicle locally or remotely. And that's a separate concept from the DMV records of who financially owns or who is this vehicle registered to. And this gets especially complex when you think of leased vehicles that might be financially owned by intermediate companies or entities in between, like who you would consider to be the end user of the vehicle.
And then this is Chris again. So isn't that, I mean, something that the independent entity can address? That, I mean, one of the things we might think that the independent entity should have the authority to do is to establish some sort of like validation or verification process. So it wouldn't just be you manufacturer must turn over or must, you know, turn on the data to anyone who asks for it. It must be something like, you know, upon verification of the following or upon proof of the following. So there would be some sort of documentary proof that both maybe the customer and the repair shop would need to provide before the manufacturer would turn over the data. And so isn't that something that the independent entity could deal with?
Possibly. I might not be following your question, but how we got to this part of the discussion was we were trying to establish, do we all agree that the independent entity doesn't house any data? And everybody was saying yes, and I said yes if we're talking about vehicle data, but I am unsure or don't actually think that Maine voters would agree to have this new government entity house the electronic records of like which car is owned by who, and their like connected services accounts that they've set up on their vehicles with their spouse or with their children or with their friend down the street.
Yeah, but I guess I don't know why the independent entity would need to house all of that.
I wasn't saying whether they need to or not. The original question was, does somebody has to house that information? That's all I'm trying to establish. And yeah.
Okay.
And today that information is housed by the vehicle manufacturer. And we were saying that the independent entity is not going to house vehicle data. And I am saying I've not yet heard what other people think on whether the independent entity houses the database that associates vehicles to owners. And I haven't heard whether the independent entity houses the database that manages the electronic accounts of independent repairs.
Jeff?
This is Jeff. I think we're really limiting the data that we're talking about to diagnostic and repair data. With respect to other data, I don't think the state of Maine should house any additional data. And I don't think it's needed to do that. And to your larger point, Chris, I absolutely agree that this is kind of part and parcel of whatever it is, whether it's advisory, whether it's something else, that the experts that the statute mandates would be able to come together and discuss in a holistic way from a perspective of, hey, I'm a shop owner and here's what I need, or I'm a manufacturer and here are my concerns, to try to have a dialogue to figure out what then those parameters are, to set those parameters at that point. I think that's when that happens. So I completely agree with you.
Jack?
Maybe to help Brian out, next time you get a few minutes, call the person or the place that you bought your vehicle from and ask them you want a key to your car. Find out how long it takes, if you can get it.
Yeah.
And I think that's what he's getting to, is that, when someone comes in, this kid going up the University of Maine in Orono, car's parked up there, can't find his keys. He can't get one. And that protects us and the manufacturer from making a key out that's accessible, that someone could drive, that you need identification, you need registration, you need a lot of paperwork, unfortunately, to get a key made anywhere in this country. And I can see what he's talking about is that if someone wants to give permission to have someone, whoever it is, work on their vehicle, how is that entity going to know that that's the right person requesting that information?
Right.
That's a very tricky situation.
Tommy, do you have a comment? No, sorry.
No, I'm just trying to get back to Christina's point. I think we're all pretty much at yes, that this is not going to be a depository of information. Now, I understand the engineers are going to have, different point of views of what exactly housing information versus not housing. This working group is designated to designate the further, entity, if you will. So I think as a guide for the layman's terms, yeah, I think we all agree that this won't be a giant depository of information.
I think also, Brian, you've already got a model. I don't know if it's the best model, but you've got a model today where you've got independent repair shops that either can have Tesla tools or they can have third-party tools. And something happens today with somebody brings their car and they authorize the work to be done. And there's some sort of vetting that you've already established that independent repair shop with their Tesla tool or a third-party tool is okay to actually do the work. I think that's what we're talking about, but making sure that they've can continue to do that work and that it's fair in terms of how things are available and are priced. But I think there's already a model that's been set that we want to ensure is going to continue and everybody else is following that.
Right. But in this existing model, Tesla is the entity that maintains a database of which vehicle owners own or are authorized to for which vehicles. So the relationship between owners and vehicles, and then we also have the responsibility on the independent repairs that they have like a electronic account that they can sign up for. And so when a repair asks an owner to be authorized, then there's some transaction that occurs between these two databases, but both databases are administered by us, the vehicle manufacturer. And in my reading of this bill, I'm worried that the administration of these databases would shift to the independent entity, which implies that the entity would have to maintain which vehicles are owned by which citizens of Maine or outside of Maine, and as well as the digital accounts for the independent repairs. So I'm all for a world where the liability and the administration remains on each vehicle manufacturer. The thing I am concerned about is shifting that responsibility and liability to the independent entity.
And Brian, I mean, I guess what I'm contemplating is that it'll still be the manufacturer's job to confirm that the person who's requesting access is the person that is properly authorized. And it sounds like for Tesla has a system that allows it to determine that information. And I'm assuming that the same is true for other manufacturers. I mean, I know for like a lot of vehicles, you lock your keys in the car and you can call up OnStar or whatever and say, hey, can you remote unlock my car? And I'm assuming that there's a process they use to confirm that you are the person who's authorized to do that. So is it safe to assume that for other manufacturers, they're going to have ways that they can confirm? Okay. And Elizabeth just said yes. So I think, I mean, my recommendation would be that this independent entity is not going to be deciding who's allowed to have access. It's going to be the job of the manufacturer to confirm that the person is properly authorized.
I think that's where we can make some recommendations for changes in wording, because that's unclear to me as a manufacturer. When I read the required equipment section, that it seems to be implying that I must equip our vehicles with this access platform that is standardized and that it's the independent entity that is administering it and choosing the standards. And so those are the aspects that I think in our recommendations we need to clarify.
That's a fair point. Elizabeth.
I really just want to echo Brian's comments and say it's not just Brian's reading of the law, and that's not just my reading of the law. It's every manufacturer's reading of the law. So we're not, kind of just out here in left field. I agree that in order to achieve what we're sort of discussing, there would have to be some changes in that component just to ensure that what we're really talking about is in fact, call it the Tesla model, the BMW model, the video that we saw a few weeks ago, right? That's that same model of approval. I think that was Europe, but it's the same basic concept. So, but I think manufacturers have read it to, at least until now, and to mean that manufacturers would not have that final authority over, keeping the access keys, essentially.
So, I mean, just to maybe step back for a second, one of the things that's kind of becoming clear to me through this discussion is I think this entity is going to have to be more than just an advisory organization. And I think that for a couple of reasons. First, like our office, I mean, our office typically relies on other agencies to sort of do all of the sort of investigatory work, to do the background work, to try to resolve situations. And then they bring it to us for enforcement when it's all sort of packaged up. And I think it would be an unusual model where the AG's office is sort of charged with enforcing this statute without having a regulatory type entity that is sort of directly involved. And so that's one reason why I think that this entity would have to be more than just advisory. And I think the other thing is that it's just sort of becoming clear during the conversation that there probably, are some things that the independent entity is going to want to address, just in terms of maybe like the terms upon which manufacturers have to provide access or guardrails that need to be in place for providing access. So I'm just not sure that this law could be properly implemented and enforced without some sort of entity that is going to be sort of directly involved in the work. And I don't know, Christina, let me just put you on the hot seat, but as the chief of the consumer division and you sort of, get involved in this work, like, do you have thoughts about whether this is something that our office could do without another entity to be working with?
Well, I had to smile when you said that we don't typically build investigations from the ground up, because in our division we actually do.
Right.
That being said, I think this is a complex area that implicates some really sticky technical issues in terms of cybersecurity, privacy, consumer protection, and I think we would need help not only in evaluating compliance, but to my earlier point, how do you get to compliance? Having some kind of entity to develop the standards for getting to where manufacturers need to be. And then the experts would help us, I think, evaluate whether they're there. But I do think that we need some kind of body that, and in my view, they would have to have rulemaking authority, I think, to develop some standards so that with some of this technical expertise, so that they have this public process for having some common sound standards that we could then look to when we have a complaint, and then look to the expertise too for consulting. This is not an area that we would typically be able to investigate on our own and build a consumer enforcement case.
But this is Brian. I have a question there about the nature of the complaints that we envision coming to the Attorney General. I envision the nature of the complaints are independent repairs stating they can't perform some capability that a manufacturer dealership can perform. That sounds great. Then we dig into the complaint and we figure out what's wrong. The standards, though, that you were just describing are about the way in which authorization occurs, or their privacy related standards, or they it's the implementation of how how access is granted. Like, I don't actually think that an independent repairer is going to come and say, well, this vehicle manufacturer is using cryptographic certificate XYZ rather than what the standard describes some other type of cryptography approach. Like, so like the whole point of the legislation is to create a level playing field and to ensure that independent repairers have the same remote access that a manufacturer dealership has, and that there is an enforcement mechanism put into place to ensure that they actually do have that access. That all sounds great to me. I worry about creating a regulatory body that is going to decide and invent like the best cybersecurity implementation across an entire industry for this very complex field. Like, I would leave it up to industry to solve like these problems rather than a government body that is lacks adequate funding or resources.
Yeah, Tina.
Brian, hi, Christina. I agree with you that there needs to be a fair amount of flexibility and latitude for the manufacturers. And I think that the independent entity can bear that in mind, and in developing kind of high level, not granular standards, they can change those standards over time, you know, if they've got rulemaking authority, and they can bear in mind when they do high level policies, the fact that we do have an ever-changing technology here. I think what I was kind of envisioning is we get a complaint from an independent repairer that says we can't, or a consumer that says my independent repair shop can't fix my automobile because they can't get to the data they need. And we reach out to the manufacturer, and the manufacturer says, yeah, we can't because blah, 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 cybersecurity problem. And we say, oh, well, we have no idea what that means. And yes, it would be great to go to the independent entity and say, hey, can you help us assess whether this really is a problem? And I think if we do that on a complaint by complaint basis, it may be difficult to have a consistent approach that truly does level the playing field if we, you know, if we're just in every instance starting from scratch, asking the independent entity to help us assess a particular defense to why it's not happening, or technological impediment to why it's not happening. I fear that that's just not going to get the job done if we're trying to open up the playing field.
Yeah, I guess I feel like the question is more simple. When a complaint comes in, the answer is either, well, is the same information provided to a dealership for repair and maintenance? Yes or no? If yes, then it needs to be available to the independent repair. If not, then it's not in scope of this regulation.
Yeah. That's just not a world that we live in, Brian. I mean, when we get complaints that companies aren't complying with a law, it's not just simple like, are you complying with it or aren't you complying with it? We get all kinds of explanations. Yes, we are complying it, but we're not really, or here's why we're not, or we can't, or I mean, you know, we're going to get all kinds of explanations from a company as to why they're not complying or that they really are complying. So I don't think it's going to be a simple phone call that's going to resolve it. And I think, you know, we also might be using standards in different ways. I mean, it might be just up to the independent entity to decide the extent to which it should be imposing any kind of like sort of uniform standards on how information needs to be provided to independent repair shops, or they may agree with what I think you're saying, Brian, which is it really should just be left to each individual manufacturer to make that decision. And as long as they standardize it across all of their vehicles, you know, there's not going to be any kind of mandate. But the other kind of standards could be sort of more less technical standards. And just to go back again to this issue of like vetting repair shops, the independent entity might decide that there needs to be some sort of credentialing process for a repair entity. So, manufacturer, before you turn over this information to this independent repair facility, you need to confirm that they are like a licensed repair facility in the state of Maine, or we're going to have a credentialing program. So, we're going to have independent repair facilities apply to the independent entity. And if we think that they're sufficiently reputable, we will issue them a credential. And then, and then once you get that credential, then manufacturers have to turn over information to you. So there could be other kinds of standards, I think, sort of beyond the ones that you're talking about. But at the end of the day, I think those are standards that the independent entity should decide, whether they're necessary or not. I'm not sure that that's the job of us, except that to the extent that we think that they are going to need to develop any kind of standards for anything, then they're going to need to have some rulemaking authority. Tina, were you trying to cut in?
Well, no, I just was going to give another example of kind of the high level policy standard that I would expect the independent entity would be responsible for promulgating. And that would be, there's been a lot of discussion about the fear of having access to a moving vehicle. So that could be one type of overarching guardrail that the independent entity could implement.
Yeah, Elizabeth?
Yeah, I just want to clarify one thing because I feel like we're back now to now we're leaving it up to the independent entity to decide whether or not it's going to be the manufacturer who's ultimately responsible for the access. Because if that's the case, I would go back to the same question of if it's not the manufacturer, then who is it? And I have not been able to get an answer to that question. And,
Yeah, I'm not saying that though.
Okay, but
yeah.
that's what I just heard though. Am I not hearing that right?
I may have misspoken, but I think what I said is that there might be some sort of like regulations that would require like a credentialing process before a manufacturer is required to turn over stuff.
Right, that's one thing.
But I'm not suggesting that the independent entity would be making the decision about whether the information gets turned over. I mean, they could have a rule, for example, that would say, no manufacturer needs to turn over data unless the person is sufficiently credentialed or something.
Okay, I
like
got you.
that.
All right. Now I
Otherwise,
see where
yeah,
you're going with
yeah,
that.
and
Okay.
I think I probably misspoke.
No,
so I
that's
apologize.
that clarifies. Thank you.
Any other comments? I'm not sure where we want to go from here. Well, do you have any thoughts, Christina, on what we should do next? I do think that that maybe it's just time to talk just a little bit about the structure of the entity. I don't know that we've really fully resolved exactly what this entity is going to be doing, but I also think that to some extent, maybe we don't need to completely because some of this is going to be left to the independent entity to decide. Although, just to Elizabeth's point, I do think we want to make it clear in either the report or in our suggested revisions to the statute that we don't envision the entity being sort of the gatekeeper of the information. But with certain things like that accepted, I think probably this independent entity is going to have some discretion. And so I'm just wondering, and I know it's getting close to 4, and so probably people are getting tired. But I'm just wondering whether it's worth just talking a little bit about how people feel about the idea of having this as some sort of like regulatory entity in state government versus an advisory group, and it could take different forms. One thing that we could use as a model potentially are licensing boards, which the state has a lot of. So just, for an example, you'll have a licensing board that's made up of various medical professionals that, is in charge of licensing doctors. And, they're all very knowledgeable in the area and they have rulemaking authority and they get complaints about, professionals and they investigate the complaints. They have authority to take some corrective action. If they can't, resolve it with their powers, they can sometimes refer the matter to the AG's office for further action. So I think that's like one kind of model. Another model would just be sort of like a more traditional like state agency, like some sort of state agency that's housed within some other agency, whether it's public safety or the Department of Administrative and Financial Services or the Secretary of State's office, but some sort of like kind of regulatory agency. And Christina, were there other some models that we sort of were tossing around?
An independent agency that's not housed within an existing department. And I think the Prescription Drug Affordability Board is probably an example of that, as is Efficiency Maine.
Efficiency Maine.
Are those regulatory or those advisory? Both the
No, well, maybe the prescription, it sounds like maybe they're just advisory. But all these other ones, so for example, all of these licensing boards are regulatory. They have rulemaking authority, they have enforcement authority, they have investigatory authority, they can serve subpoenas in a lot of cases. Things like Efficiency Maine, trying to think what else, like FAME,
Housing.
yeah, there are a lot of these, what we sort of refer to them as like quasi-governmental agencies, because they're not, and it's kind of a loose term and it means different things, to different people sometimes, but these are entities that aren't really directly under state control. So it might be that various people within state government appoint people to serve on the board. But then, you know, at that point, then they have a lot of autonomy, and they can still have rulemaking authority and enforcement authority and everything else. Yeah.
Do those examples have licensing or accreditation authority?
Yes. Yeah. I mean, the legislature is free to do whatever it wants in terms, well, not whatever it wants, but the legislature is going to have a lot of latitude. So if our recommendation is, and they accept our recommendation, that the statute should give this independent entity authority to credential independent repair shops, that would certainly be within the legislature's power to do that. Was that your question, Brian? Did I answer that?
Yes. And it goes with subsection A that talks about accreditation and certification of organizations. So it's within the current wording that that might be a responsibility that they hold.
So I think we'd like time to, you said you've named two kind of advisory panels here or regulatory bodies that this could be comparable to. I think we'd like time. I mean, the group maybe wants time to kind of explore those and, you know, how they work. You know, from our standpoint, I think a lot of the frustration comes from the fact that we are not the engineering experts, right? So we don't know exactly what you need. It's actually a very simple thing, what 84% of painters voted for, which is access to their own data and to share with an independent repair. Now, when you get into the credentialing and when you get into the authentication and tokens and digital certificates, that's where the engineers are going to go to work. So for me, the simpler, the better. Our job is not to decide authentication and accreditation. Our job is to say, these are the following folks that are going to sit on here and they're going to hammer this out, because we can't do this without the participation of the manufacturers. So like I said, for years, we tried to reach out. No one gets back to us. You pass a law, you get groups like this together, you mandate that they're at the table, and that's how you kind of get things done. And so for me, I think, you know, the simpler, the better, to get the right experts that have the right expertise to figure out how this is going to be implemented. And to Brian's point, I don't think you need a mandate of technology. I don't think you need a mandate of standards, but I think it has to live in the parameters because, again, this is a very simple concept. It's a matter of making sure that everyone gets together and hammers out the details. So advisory to enforcement, I think for right now, I'm happy to check out the other boards, but keeping this simple and getting the right folks in the room together, I think you're going to find this to be a lot simpler than a lot of the questions that unfortunately we can't answer.
Yeah, Jeff.
So with you know, with this passing by such a large margin as it did with voters, 85%, one of the things that I'd like to explore is, you know, how to accomplish this in a manner that costs the taxpayers the least amount of money, that causes the least amount of delay possible, because, you know, cars are being manufactured right now and they're going to be out of warranty soon. And Mainers deserve a choice about whether or not to take that vehicle to an independent repair shop or whether or not they have to wait longer and pay more to take it to a dealership. And so, you know, those are things that are concerned because sometimes, you know, that really affects the bottom line here, and that affects whether or not independent repairers can continue to operate and their shops, and whether or not you know, car owners have the choice. And so kind of like to think about and explore those types of issues, Chris.
And for what it's worth, and I'm not pushing one model or another, but I just wanted to just provide some more information. My understanding of most licensing boards is that all of the board members serve without compensation. They may get like some per diem or travel or whatever, but they're not getting a salary. So to that extent, financially, those boards operate pretty leanly. Most of the boards, and I think in this case, if this was the model that we chose, there would need to be some professional staff that the board could call upon. So like an executive director potentially, or some sort of investigator or technical person. I don't think that there's any way of implementing this law at zero cost. I think there's going to have to be some cost because this is just a very complicated technical area. It affects a lot of people, a lot of companies. I think that there are going to be a lot of issues that are going to arise, and so I think there are going to have to be some financial resources. But it might be that sort of a board model, might be more economical. I mean, assuming that we can get the people that want to serve on the board and devote the time to it. So I'm just throwing that out for what it's worth. And again, I'm not trying to sell that model, but I did hear you, Jeff, suggesting that the finances is sort of part of the calculus, and so I just wanted to point that out.
This is Brian. And the third model, which I think is the least amount of taxpayer money and the least amount of delay, is a no board model. Just delete section 2 and enforce the rest of the bill. But somebody mentions that we should find the most simplistic solution. That sounds like this whole working group, we're hung up on the language in section 2. Well, let's just get rid of it.
Well, except we're not really hung up on that language so much as we're hung up on the resolve that directed us to develop recommendations to establish the entity that's going to implement the statute. So, I mean, I'm not sure that precludes us from recognizing there doesn't need to be an entity, and maybe that could be our recommendation. But I'm more focused on that the legislature does seem to have directed us to decide what this entity should look like and what it should do. But that's not to say, Brian, that we couldn't have a recommendation that we really don't need an entity. I will say though, and this just is sort of what Christina and I were saying before, that without some kind of other entity, I think it would be very challenging for this law to be properly administered and enforced. Yes, Christina?
And can I just follow up on that a little bit, Christina, from the Consumer Protection Division? I think we can hire experts when we're investigating cases if we get a complaint. But I think that the concept of the independent entity with combined expertise from all sides of the issue is going to give us a much more balanced and fair approach to figuring out whether there's an enforcement issue.
Which is probably the case of what Jeff referenced with the prescription drugs. You've got experts that they pull together to help with situations like that.
I feel like I almost got Tesla to say that they support the ballot initiative of this. Is that fair, Brian? You can support the initiative without section 2 in here?
Well, I did. That's what we supported last, whatever the alternative bill that was put to the House earlier, where it was very similar to eliminating section 2.
Yeah,
yeah.
I was half joking. I was half joking. I don't think they're the same.
Yeah, Christina? Yeah. Jack, why don't you
I
go?
don't know if this question has been asked or answered. When it comes to access to this information, is this after the vehicle is out of warranty, or does it start the day that the customer buys a vehicle and
I think it starts the minute the customer buys the vehicle.
so even while it's under warranty, it's
Right, because I think customers do have the right to have their warranty vehicles repaired at independent repair shops.
okay. No, I
So-
just want to know how that.
Yeah, and I think
Same as today, right?
from day
Same as
one.
today, you could bring your car anywhere you want to bring it, right?
Well, no, I know that. I just
Yeah.
want to know if the access to the, everything that we're talking about here. I wasn't sure what the that's no problem. So.
Yeah, Christina.
Hi, Christina Moylan. I just want to, this is brainstorming session, I think, which is really useful. And so I don't want my perspective as an enforcer from the Consumer Protection Division to necessarily communicate that from my perspective, we would rule out if there is some other way to get us the expertise, balanced expertise that we would need in order to enforce this law, that I don't want to suggest that the Attorney General would stand in the way. If everybody else agreed, the best way to do this is to not do it through an independent entity, but some other lighter touch, so long as the enforcer has, as I said, some balanced information that we could use. And one mechanism could be to actually beef up some of the substantive provisions of the law. And that might help give us some guardrails and parameters that would help us. And as I said, also, we would need that balanced expertise that maybe there's another way to do it. But I didn't want my comments to suggest to the group that, we wouldn't consider that if that's what everybody thought that we should recommend.
What do folks think? Are we at just a stopping point, do we think? And we want to mull things over and regroup in a couple of weeks?
Is it possible to hear from some of the other members that haven't been as vocal on what they're thinking? I don't want to put anyone on the spot, but just to hear from the other members of it, Megan and the rep of the Secretary of State, just for a 2 cents, if you will,
Lynn Gardner from the Bureau of Motor Vehicles. I actually would be interested in, before we part, if we could just kind of maybe we've thrown out a bunch of different sort of names and boards and stuff. If we could just kind of have a little why don't we kind of look at this and that and the other, so that when we go away, we can know that we're all kind of looking at the same sorts of things before we come back.
Yeah, that's a good idea. And my thought is maybe Christina and I, by the end of this week, we could just shoot out an email to folks, which would list some possible models along with the statutory citations. Does that make sense? Yeah, does that sound good? Yeah, because I think that's a good idea, so people can actually look at those. Yeah.
I prefer things in writing. So.
Yeah. No, I think that make more
I'm all
sense.
for
And then,
it.
yeah. Okay.
Christina, I also think it might be useful for the group if Chris and I start putting pen to paper to memorialize the agreement that we seem to have reached for some of the statutory amendments that we would recommend. I'm not sure if we can do that by the next meeting. I certainly don't think we can do it by the end of the week, but I think that might be a useful tool to have a document that we can all start working from and weighing in on.
That makes sense.
All right. Any other business? All right. We are adjourned. Thank you, everyone.
Happy Halloween.
Happy Halloween.
Thank you.